We're live.
Okay. Good morning. This is Senate Judiciary for Friday, February 24th, 2023. We are meeting this morning on the annual act relating to miscellaneous judiciary procedures, which normally has a bunch of miscellaneous items in it, usually technical. And Eric Fitzpatrick is here to walk us through it. Then we have several witnesses on certain parts of it. Well, go ahead, Eric, please.
Thank you, Senator Sears. This is Eric Fitzpatrick with the Office of Legislative Counsel, here to walk the committee through, as Senator Sears said, this year's miscellaneous judiciary bill. Would it be helpful to share the screen, Senator Sears?
Probably, thank you.
Sure. A moment of background while we do that, as Senator Sears mentioned, this is an annual bill. And this covers technical judiciary issues as well as other policy issues, other smaller policy issues that maybe are viewed as not necessarily warranting their own bill, but are maybe a good idea to pass, depending on what the committee feels. Oftentimes, when you see some of these sections are from a variety of sources, and for example, during the summer and fall, our office gets all the new laws that have been passed ready for publication. The Vermont statutes annotated. That involves a review, an editing, proofing process by our office during the summer. Sometimes we'll catch technical fixes that need to be made, errors in the statute, so we'll note those over the summer. Other times I will hear, since I've been doing miscellaneous bill for a number of years, I'll hear from the court over the summer or from the state's attorneys, the members of private practice about possible technical fixes or small procedural items that might be good for the miscellaneous bill. I'll run those by Senator Sears, and we'll gather them together to include in the miscellaneous bill each year. So one also interesting note is that recently what's started is that where the bill starts rotates between the House and the Senate Judiciary Committees. So this year it's the Senate Judiciary's turn to start it. Last year it started in House Judiciary. So that's why I'm presenting it to you for the first time. And next year we'll start in the House as well. So with that as background, I can jump right into walking through the different sections of the bill. As you see, there's quite a few. So if I'm going too quickly, stop me if there's any questions or wondering where certain pieces came from, that sort of thing. So the first section is about as technical as it gets, and this was something that was noticed by our office over the summer while we were republishing the statutes. You'll see that there's a missing subsection heading. Subsection headings in that statute were there for A through G, I believe it was, but subsection F was missing the subsection heading repeal, so that's placed in, purely technical. Section 2 is a request from the court, and this has to do with the authority that the Chief Superior Judge now has to assign judicial officers to hear cases when there's a particular need. So currently, the Chief Superior Judge, you can see on lines 4 through 6 of page 2. Currently, the Chief Superior Judge has this authority, can assign another Superior Judge, a probate judge, a family division magistrate, judicial hearing officer. It's called a special assignment to sit on a particular case when there's a need. What this proposal from the court does is it adds one more judicial officer to that list of officers whom the Chief Superior Judge can assign, and that's the judicial master. And that's a recently created position within the judiciary, and they have a very particular authority, which is to hear proceedings involving, for example, compliance with parent-child contact orders, compliance with orders in judicial proceedings, that sort of thing. It's similar conceptually to the family division magistrate, which also has a very particular jurisdiction, the types of cases they can hear. This allows, when there's a particular need, the Chief Superior Judge to say, hey, there's a case that needs a judicial officer, and one of you other judicial officers cover this case. As I say, it's an existing authority that just expands by one of the other judicial officers that they have.
Eric, quick question.
Yeah.
Is that something that was made as a request in order to help with the backlog?
That's my understanding. I think Judge Zone will be able to give you even more background as to where it comes from, but that's exactly my understanding. Yeah. Section 3, also purely technical. You'll see we have a missing conjunction on line 2, page 3. In need of an and, so it's added there. Section 4, this is also a request from the court as well as from the court committee on civil rules. This has to do with the ability of pro se parties to file statements in connection with court proceedings. Right now, and this stems from COVID also actually, Senator Sheen, as you were mentioning, the previous one, sort of a COVID backlog connected COVID too. This also conceptually started during COVID. And at that time, whenever someone needed to file a pleading or other document in a court case that needed to be sworn, you had to swear it in person before a notary public, and they had to attest that you swore it, and then it had to be submitted to the court. During COVID, obviously, it was much more difficult than for someone to get in person with a notary and swear a document. So there was an emergency rule adopted as well as a temporary statute that has since gone away because the state of emergency that doesn't exist anymore. But there was a statute in place and a rule at the time that permitted registered filers, basically applied to attorneys only, registered filers in the court's system, instead of having their document notarized, instead they could just submit it with the statement that you see on page 3, lines 12 through 15. So instead of having to go before a notary public and get it notarized, they could just put that statement on there and attest to the truth, right? However, what the court noticed now, and what is the reason I think that the Rules Committee and the court wanted to make this change, is that that ability to file a document with an attestation instead of having to go in person before a notary public doesn't extend to pro se parties, parties who are filing themselves without an attorney. They still have to go before a notary public and have it sworn. So you see, that's the proposal here in lines 8 and 9. It strikes out the piece that says, well, it's only a registered electronic filer in the judiciary's electronic document filing system. In other words, an attorney. And allows any document that would otherwise require approval or verification by a notary to be filed with that same statement that I just referenced. So a person could, instead of having to have it in person notarized, can instead put that statement on it, attest to its truth, and that would be okay.
So Eric, so currently this is so people can insert this language without having to notarize things.
Attorneys can. Yeah,
Attorneys
exactly.
can, okay.
That's right.
But this is extending it so that pro se litigants can also do that themselves.
Exactly.
And this only applies to court documents that need to be notarized? Or,
Correct.
okay, so it doesn't just like do away with the need for notaries?
Definitely, right. Court filings only. Let's see, let's move on to section 5. And also another missing and, you'll see that, a missing conjunction there, and that one, line 8, added in this section. Section 6, another missing subsection heading. See that in line 12? Again, just a heading to a subsection, not changing any law, and that was missing as well. Section 7, also technical because it's correcting an outdated cross-reference. So line 6 and 7 used to refer to Rule 6 of the Rules of Electronic Access to Court Records. Those records now have a different title. Instead of being called that, they're called the Rules for Public Access to Court Records. So the title is corrected.
So this is an addition, Eric, here on page 4, line 12,
Yes,
composition of the court.
but it's just a heading to a subsection. It doesn't actually change the law in the section. We don't put, for example, look at line 17. There, subsection A doesn't have a heading. It doesn't have a little title. Some statutes of law have these subsection headings, some don't. According to our editorial staff, if you've got subsections A through D, and A, B, and C have a heading, then you have to have one for D too. For technical, they all have to have one, or none can have one, no in between. So some subsection headings violated that rule, according to our editors. So it's added there, so that it's in compliance. Does that make sense?
Mhm.
Right. So where were we? Section 7. Oh, we did the cross-reference in section 7, right? Section 8. So this involves some legislation that was passed by the General Assembly several years ago. It was known as Day is a Day. The Day is a Day of legislation. And what does that mean? Well, what it means is that there are many, this is again, Senator Mahowski, this is similar to your question that you had earlier. This only applies to court proceedings, not sort of generally across the board. But when there are references in statute to time requirements in court proceedings, sometimes there will be references to something has to be done within a particular number of days. It has to be filed, maybe an answer has to be filed, some sort of court pleading has to be filed, and there is a particular number of days within which that has to be done. Prior to the Day is a Day legislation that passed a few years ago, what that statement of days meant varied depending on the amount of days. If it was, I think if it was more than 10, then it did not include weekends and holidays. But if it was 10 or less, then it did include weekends and holidays. So rather than, and that led to some confusion. So day is a day means, all right, we're going to change that. And so whenever statutes refer to days with respect to court proceedings, it just means days. You count weekends, you count holidays, everything, you just count that number of days. But in order to make that, since you then were going to not be counting weekends and holidays anymore, you didn't want to inadvertently shorten time periods, because something said 5 days beforehand, but it didn't count weekends and holidays. And then going forward, it said 5 days. And, if it was 5 days, that's right, and it didn't count weekends and holidays. Going forward, it's 5 days and it doesn't, you could accidentally shorten the time period. Because in some cases, that 5 days would be, say, 7, if it happened, say, if it landed on a Thursday, because you don't count Saturday and Sunday. So in order to true all that up, legislature went through and corrected statutes. And for example, every time the statutes referred to 5 days in a court proceeding, change it to 7. Every time it referred to 3, change it to 5. Again, one was missed. That's what's going on in Section 8. You look at lines 17 through 8, had said 5 business days. To be consistent with the days a day, then it changes the 5 to 7. So more background than there is statutory change that helps you understand what that change is supposed to be made. All right, now we're moving on to Section 9, and this is a raise in the jurisdictional limit for small claims actions. So right now, with respect to a small claims action, the jurisdictional limit, and that means that the amount of damages that a person can have at the most for them to be able to file an action in small claims court right now is $5,000. So if it's above 5,000, you have to file a court case in the civil division of the Superior Court. If it's 5,000 or less, then you can file a small claims case. So the proposal is to change that 5,000 to 10,000.
And actually, I can imagine this is probably a question for the court, but in case you know, is this something that is meant to, again, expedite the process and avoid adding more things to the civil docket?
This actually, I'm going to defer to Senator Sears on this, because this actually was not a court request. This was one that Senator Sears wanted to put in.
Thanks.
Yeah.
Senator, you're on mute.
Yep, no, the amount for staying in small claims hasn't been increased in, I think, 20 or 30 years. And this is just an effort by some to increase where you can go to small claims court if you have cases under 5,000 currently. And I think Peg Flaherty was chair of Judiciary in the House. Last time we raised it from 3,500 to 5,000.
Yep.
And this is a proposal to go to 10,000. It just, given inflation and so forth, that's all it is the decision to raise the amount.
Thank you, Senator.
So moving on to Section 10. This is also a request from the court. It's a modernization in terminology. You'll see that with respect to the oath to be administered to jurors in criminal cases, right now it refers on line 6 to the prisoner at the bar. That is an ancient term that was a reference to a criminal defendant, someone who was on trial. I think the Defender General, which witnesses in the room will have a better understanding of this than I will, but I think that comes from literally, it used to be in the courtroom. The defendant was standing at the bar, and so that's why it was referred to as the prisoner at the bar. It was on one side of the bar, and the other attorneys and other folks in the courtroom were on the other side. But we no longer use that term, as far as I know, so the term is modernized to be referred to the defendant rather than the prisoner at the bar. Section 11 is another correction of an inaccurate cross-reference. That statute that it refers to has been repealed, no longer exists, so can't cross-reference that. It's been corrected to the statute that it refers to now is the one that replaced it. That's all that is. Section 12. Now, this one was requested by the Department of State's attorneys, and this involves the state's right to appeal in criminal cases, right? So, you know, if there's an acquittal, if a person is found not guilty, the state can't appeal in a criminal case. That would be unconstitutional. It's a double jeopardy violation. However, in other parts of the proceedings before the final verdict, there are some instances in which the statute that you're looking at gives the state the right to take an appeal. So the language that's used, you'll see in the statute, for example, line 14 of page 7, reads the language in a prosecution for a misdemeanor. Page 8, line 1, in a prosecution for a felony, and also line 4 in a prosecution for a felony, and it sets out, well, these are the circumstances in which the state can appeal in a criminal proceeding for prosecutions for misdemeanors or felonies. However, there was a couple of Vermont Supreme Court cases that said that that terminology, prosecution for misdemeanor, prosecution for a felony, refers only to adult criminal cases. So that means the state can appeal in these situations for adult criminal cases, but does not have the right to appeal comparable comparable motions in a juvenile proceeding. So the court specifically said, interestingly, in one of these cases, said because the state, I'm going to quote from it right now just because it's interesting, relative to what you're thinking about doing today, because the state's right to appeal is statutorily granted, the legislature, not the judiciary, has the authority to expand this right under section 7403, that's the statute you're looking at, to include delinquency proceedings if it so chooses. So essentially they defer to the legislature whether or not you want to make any changes to this statute. It's a policy decision for you. The proposal is to provide the state with a comparable right to appeal in juvenile proceedings that it currently has under this statute in criminal proceedings, and that's over on page 9. So you see, it essentially redefined the terms that I was just referring to, in which the court in those decisions said, hey, these terms only apply to adult criminal proceedings. This proposes to say, for purposes of this section, prosecution for a misdemeanor and prosecution for a felony shall include delinquency and youthful offender proceedings filed pursuant to, and those are delinquency and youthful offender chapters. And the state shall have the same right of appeal in those proceedings as it has in criminal proceedings under this section. So that's the proposal. As I said, it came from the Department of State's attorneys, and that's where it originates. Section 13, you'll see line 11, another missing subsection heading. So our editorial staff always picks up on those missing subsection headings, so this is where they end up. All right, section 14, this has to do with this is a request from the court. Actually, these two sections, 14 and 15, are connected, and they have to do with the ignition interlock system that we have for folks who have DUI convictions. And this clarifies that, because in addition to it being an offense for you to tamper with your own ignition interlock system, it's an offense to tamper with an ignition interlock device on behalf of someone else who's prohibited from driving. So, yes. When the legislature passed that provision, it was pretty fairly clear, but not entirely clear, that they intended that to be a civil offense, not a criminal. When someone tampers on behalf of someone else, it's supposed to be a civil offense. But the language that was used at the time, I think it came out of the Transportation Committee, and so the language was not quite identical to the language that is usually used for a civil violation. So this proposes to use the boilerplate civil violation language that you always use which is line 19. We don't say adjudicate, you say assess a civil penalty. That's always the way a civil violation is phrased. And you also must, and this is on page 11, you also must clarify that and make it explicit that the Judicial Bureau, which handles civil violations, has jurisdiction over these particular types of cases. You can see, because on line 7 and 8, it proposes to add this one, violations of this statute relating to tampering with an ignition interlock device on behalf of another person. So that's another thing that made it ambiguous, because usually, it's supposed to be when there's a civil violation, you add to the jurisdiction of the Judicial Bureau to make it clear that they can hear those cases. That wasn't there. So that's another reason that it was unclear. So this just clarifies that's a civil violation, not a criminal one. For tampering on behalf of someone else.
Eric,
Yeah,
if I may, Mike, my understanding is that the people who have a civil suspension, you receive a 90-day suspension, but if the reduced, you take a plea and a reduced charge of negligence operation, you're not eligible for the interlock device until your 30-day suspension for negligent operation is served. In other words, with a negligent operation, you have a 30-day hard suspension and can't get the interlock device. But if you have a DUI, you can. Did I send you a copy of that email from David Silver about this?
that does ring a bell. Yeah, I'm not.
It seems totally unfair that if you have a reduced charge, you can't get the interlock.
Right. Yeah.
Why don't let me forward that email to you and we can look at an amendment that will allow people who are under a 30-day suspension to get the interlock device. I don't know why you'd be able to get it if you have the more serious crime of DUI than negligent operation.
Right.
I'm going to forward you that email.
Okay. Yeah. Thank you. Please do that. So we're ready to move along to the next section?
Yeah.
This has to do with, this is actually just correcting a redundancy that has to do with the fees that sheriffs can collect for certain types of court process. And you see, if you look over at page 12, the redundancy I'm talking about, the technical fix, and I ran this by the Sheriff's Association, they agree, it's just essentially a typo. You see lines 5 and 6, and subdivision 3 is saying, all right, they can charge a $75 fee for service of papers relating to civil suits, except as provided in subdivisions 2, 7, and 1A. But if you look at subdivision 2, which is just right above it, on same lines 1, 2, 3, that also provides a $75 fee. So it's not accurate to say except as provided in subdivision 2, because subdivision 2 provides exactly the same $75 fee that subdivision 3 is. So it just deletes that cross-reference, subdivision 2, and keeps the elements. So that in the other situations, it isn't always $75, but in those two cases, it happens to be.
Thanks, Eric. So I know this is a technical fix, but what exactly is this section for? I mean, who is it? Just the courts that are paying sheriffs $15 for each arrest? I mean, what is this whole section? Is my general question.
Yeah, I think
it
permits them to, and Senator Norris, I'm sure be able to answer better than I would, but I think it just permits them to charge this fee when it is when it fits within the statute. For example, if you're serving a complaint on somebody in a civil trial and you have the sheriff serve it, they can charge a fee. And ordinarily, at least what I remember from civil practice, is that the plaintiff's attorney would pay the fee. It wouldn't necessarily be the court, but in other situations, it might be the court. But I remember it being that we had to pay for it.
Thus the plaintiff will end up paying the fee.
I was gonna say, it really seems like we're charging people for arresting them.
This is civil process.
Right,
Well-
you're getting sued.
Yeah, this is,
So under civil process, what circumstance would somebody be getting arrested?
I see in subsection B, it says for each arrest, $15, for taking bail, $15.
we've never,
I don't know, that's a
I've
good
never personally
question.
done that, but what I can tell you is a lot of times in a civil proceeding, small claims or whatever, the judge will set bail. And parties who were successful in their suit may have had, tried to get back damages for say $1,000. So the judge would put an arrest warrant out, not a civil arrest warrant, but it goes to jail with these things.
Yeah.
And I could go up and collect bail. The problem is instead of like at $200, and then a month later, I'd be going back up again to collect. So we were able to work it out that just set the bail at what the success was. $1,000, they want set bail at $1,000. Because that was like a collection agency. I was just running all over the county, just collecting $200 bail every other week. I mean, it's just, I've never charged the $15 for arrest or what's the other one? This is new to me.
For bail.
Yeah, for bail. I've never done this.
Yeah, I was just wondering, I had never heard of this, and yeah, thanks. Yeah.
Am I correct on that, gentlemen, or?
Yeah, I think typically it's, the only times that I've ever heard of sheriffs being involved in a civil arrest is essentially to get somebody to a civil case that they don't want to go to.
Failure to appear
Yeah.
for, for show cause why you didn't pay your civil fine or whatever.
And most of the times, probably 99 out of 100 times with that incident, but I won't even put them in my car to bring them there. I say, this is where we're going, I'll follow you down because they got to get back to their house, obviously. It's a simple thing. It's not really a criminal thing. And they were 9 out of 10 times they were qualified. So
And that's just to point out the word civil arrest here specifically means civil arrest as conducted by sheriffs in Vermont, which is a really limited scope. Civil arrest, broadly speaking, is much bigger and can include, for example, immigration arrests and things like that, which are far more serious and look a lot more like a criminal arrest than what we're talking about here.
Thank you.
But that wouldn't apply to this because this is only dealing with what the sheriffs do, not what other civil arrest powers might be.
Eric, did you say this came from the Sheriff's Association?
No, it was actually noticed by our office.
Okay,
I ran it by the Sheriff's Association and they agreed that it was a technical fix.
okay. They could, if the committee would like, we could probably ask them to come in at the next meeting, and explain section 16 to us.
explain what I'm right here.
Well, I think Senator Norris already has.
With the help of Marshall and Matt, obviously, yes.
Yeah. All right,
All right, so moving on, section 17 is probably familiar to everybody because this is the exact same provision that's in S4 that makes juvenile case records available to NICS, the National Instant Criminal Background Check System, when a person under 21 tries to purchase a firearm. So it's to be consistent with the congressional passage of the bipartisan safer communities act.
Don't we have something similar to this in S4?
Exactly the same. Yeah,
Okay.
yeah. So it was, I think there was a beginning, there's actually this provision is also in a couple of House bills. Kind of, I think the legislature wanted to make sure it got passed, so it's in a few different places.
So we really want to do that.
If
Got
you
it.
choose to, right? Right. And later on, you can always remove it from some if you see like one bill is moving, it's gonna pass. Or since they're all identical verbatim, it's okay if it passes in more than one place. So either way is fine.
I just wondered if it was somehow different and I was
Right.
missing something.
No, you were right. The next two sections, 18 and 19, are requests from the Juvenile Justice Stakeholders Group that were passed along through the court. The first one, section 18, has to do with the risk and need screening that has to be offered to a child before the preliminary hearing in juvenile proceedings. So under current law, in juvenile proceedings, this risk and need screening has to be offered. You see, that's line 6 and 7. Child shall be afforded an opportunity to undergo a risk and need screening. So this section provides some language that makes clear that any information that's derived from that screening that's related to the offense can't be used later against the child for any purpose. So that's the idea. See that? So if the language is over on page 15, lines 4 to 10. So again, the child has to be afforded this opportunity to have the risk and need screening. If they choose to do it, if they have it, then subdivision 3 applies. Information related to the present offense that's directly or indirectly derived from the screening or from other conversations, and it's DCF, it's the department that refers to other conversations with DCF or the community-based provider who does the screening, shall not be used against the youth in the use case for any purpose, including impeachment, cross-examination, provided that the fact of the youth's participation may be used. So in other words, just the fact that they participate is okay, but no information that's derived from it relating to the offense. The next section, section 19, also recommended from the Juvenile Justice Stakeholders Group. This essentially provides the court with an alternative in youthful offender cases. So, generally speaking, a youthful offender case, as it proceeds, there's a disposition plan that the court approves. This allows an alternative to that. So, and the disposition plan includes juvenile probation and whatever other requirements that are deemed appropriate. This provides an alternative to that. So instead of having a disposition case plan, the court can instead refer the child directly to, and this is line 13, directly to a youth-appropriate community-based provider that's been approved by DCF. So instead of doing the case plan route, they can go right to a community-based provider. They include a community justice center or a balanced and restorative justice program. This referral wouldn't require probation. And then the last line 17 through 20, if that provider doesn't accept the case, or if the child fails to complete the program, then the case comes back to court for imposition of the disposition order. It's sort of a different alternative, different treatment alternative rather than a disposition case plan. Senator Sheehan, I think Mark Senator.
I was only just going to clarify if there's any questions about that this is actually something that exists already in juvenile law. And I think that when we were writing the youthful offender, or it exists in the youthful offender, and we were like, why doesn't it exist in juvenile? I forgot which was which. This is a youthful offender. So it exists in juvenile, and we were all like, why does this not exist in youthful offender also? Nobody had an answer for it. So this is just taking language directly out of the juvenile statute and saying, if judges have this opportunity in the juvenile court, then when they're also in the juvenile court with a YO status kid, they should have the same opportunity.
Sounds to me.
It would honestly was an inadvertent when the youthful offender law was being drafted, we never meant to exclude.
We always forget.
We always forget the CJCs. So.
All right, can we go back one section to
Yeah.
page 15, line 8? I'm just wondering, I understand the cross-examination piece, but why is impeachment included there too? If you have any.
I don't have an answer for the why. That would be to maybe talk to Judge Zone as they came to the court or the Juvenile Justice Stakeholders Group. I mean, the practical effect of it is that, that you're kind of getting at, that the information, I suppose if you're looking, I'll defer to the witnesses, but if you're trying not to have information that the youth discloses ever, for the course of treatment or the course of this risk and need screening, which they're trying to disclose that information for purposes of being treated for their risk and other needs. Then you don't want it used against them later on for any purpose. And that could be cross-examination, but it could be to impeach a witness as well, to undermine the credibility of a witness, which could be the negative use of information that the youth had disclosed.
Yeah. Okay, thank you. I think I have some thoughts on this, but we're going to percolate for a bit longer.
Okay.
Thanks.
Sure. So that is it for this, other than the effective date. Effective date is on passage, but that takes us through the walkthrough of the multiple petitions in the miscellaneous bill.
Sorry, Rapolsky.
Yeah, and this is certainly, I think, believe Senator Hashim and I were supposed to work with you to get a domestic terrorism chapter created in the miscellaneous bill.
Oh, I remember that.
And obviously we did not do that, but I would like to. So I just want to flag that.
Yeah, thank you. I had to remember to do that.
Okay,
And then I think there were a couple of things that are housed in a couple different current places that would get moved into that chapter.
Yes, I remember there's a domestic terrorism statute that I can't remember where it was located, some strange other chapter, I can't recall what it was. Not at the top.
Bribery
We
or
already have.
Right, but I mean, they want to put it in a separate chapter rather than locate it where it's located now. Which I think, well, yeah, bribery or
It
something.
was something like that, and then the new paramilitary training camp would also go under that domestic
right.
terrorism chapter.
Right.
Because right now, they're housed in would be housed in two totally separate places.
well, it has to pass the House first, signed by the governor. Technically,
Well, I didn't quite follow that, Senator Sears, we were saying something about the,
in order to put that section in there, it would have to pass the House and be signed by the governor, and then it
Yes.
would go in there, or does the House need to change the language to put it in that statute, Eric,
that's a good
in that
question.
section?
It's already, yeah, it's already passed the Senate elsewhere. So that would be unusual, probably to put that sort of halfway through, but not to say it's impossible. So let me think on that and think about whether or not
Okay.
that's.
I mean, the House could obviously make an amendment that would put it into that statute, right?
Yes,
And they would be also be dealing with a miscellaneous bill, so it wouldn't be inconsistent. I just, if you check that out to make sure we can do it.
it might involve something like, because if the chapter doesn't exist yet, so you need to create the chapter first before the
Yeah.
paramilitary provision was added to it.
We might have to do it in the miscellaneous bill next year.
Right. Give us a good placeholder. But it could also work if you made the paramilitary, you might not want to do that though. You'd have to, if you made the paramilitary training camp bill effective July 2nd, and you made this effective July 1st, you could do it. But you may not want to do that with the paramilitary bill.
Well, this is effective on passage, isn't it?
Right.
Yep.
I don't know exactly when that would be, so. just to
Presumably
see.
before July 1st, though.
Hopefully.
Okay,
But
why-
sometimes he signs, it all depends when the governor signs it, so.
You've got to do an amendment for it anyway, and why don't we think about that between now and the time we pass the bill or ask the House to add an amendment to S3.
Sounds good.
Okay.
I think we're all agreed on what we want to do, but the question is, can we do it this year? So our next witness is Judge Zone.
Should I stop sharing my screen, Senator Sears?
Yeah, please.
Good morning. Tom
morning.
Zone, Chief Superior Judge. And so I will say that Eric did an exceptional job outlining the bill. So I'm not going to hit every part. If there's any questions, let me know, of course, but there was 2 points I wanted to touch on. The first one was in section 2 about the judicial master. Currently, the Chief Superior Judge does have the authority to appoint the judicial master under Title IV, Section 36 to serve as an acting judge. However, it's an appointment that says that you can appoint a member of the Vermont Bar. And the request that I put in was because a judicial master is actually the only judicial officer who is not listed in Section 22. And I think it's a more appropriate mechanism to appoint a judicial officer under Section 22 where all other judicial officers are mentioned. This doesn't change the fact that we can do it today. It just puts it in the section where I think it is most appropriate. And that is to have a judicial officer assigned to be sitting as a special superior court judge. And the other one I wanted to mention was in section 18, there was a question, I believe, from Senator Hashim, on the information about the risk assessments. Am I correct, Senator?
Yes, yes, you
All
are.
right. I believe that derives in large part from the structure of the idea that if you have a procedure that you are affording to youth to participate in, that you don't want to use it against them when they participate in the procedure that is intended to benefit them. And I would note that, for instance, under Title 13 for Section 4816, under competency evaluations, subsection D does say that no statement made in the course of the examination by the person examined, whether or not they've consented to the examination, shall be admitted as evidence in any criminal proceeding for the purpose of proving the commission of the criminal offense or for the purpose of impeaching the testimony of the person. And so what this really does is it aligns it with how we treat competencies in many ways. And that is, if you're participating in this process, we can't use it against you.
Understood. Thank you.
So those were the 2 points I was going to address. Certainly, if the committee has any questions on any of the remaining sections, I'd be happy to address them.
Any questions?
None in the room.
Thank you.
All right. Can I ask? I generally would stay on the line, but is there any objection if I signed off at this time?
No, no. If we make any changes, we certainly run them by you.
That's fine. Thank you, everyone. Have a safe day and have a
Thank
great
you.
weekend.
You too. Next is Matt Valerio or Marshall Paul or both.
Yeah, I'll let you do that. But I actually don't understand. Good morning, Matt Blair.
Morning.
General. We are typically in on these bills because in the past they sometimes have little hidden landmines that are not actually fully apparent by the title miscellaneous Judiciary Procedure Bill. I read through this and didn't find any particular issues except for what Marshall's going to talk about in a second. And I then went through it with Judge Zone yesterday. Again, aside from what Marshall's going to talk about, we don't have any objection to the bill. And as it was written, Marshall's going to pick up on the issue of the youthful offender section, and I'm going to let him just do that, if that's all right.
That's fine. Thank you.
It's not Mark.
Oh, it's not?
That's
No,
It's not
that's
there.
there.
I almost gave away your computer.
Thanks for,
Sorry
thanks for
about that.
checking.
I didn't check, I just tried to get to that. Thank you, Marshall Paul from the Office of the Juvenile Defender, Chief Juvenile Defender. Our only concern here is in section 12, which is related to appeals by the state, and the idea of that was to expand the ability to appeal by the state, because the state's appeals are limited by statute, and it's to expand it to include both youthful offender and delinquency provisions. We don't actually have a concern with that extending to youthful offender provisions. We think that that's consistent with the structure of the youthful offender and juvenile systems, because a youthful offender charge really is an adult deferred conviction charge that uses the venue of the juvenile court to provide confidentiality. And so from our perspective, it would be consistent to say, yeah, give the state the same rights to appeal in a youthful offender case that they have in an adult case. It doesn't make sense for a straight juvenile delinquency case. And that was a purposeful decision. There's never been a state's right to appeal. The state has always been limited in their right to appeal in juvenile delinquency cases, and that's been intentional. That's because we look at the juvenile delinquency process as a short, less formal process. There's less rules applied than in criminal court, and a lot of the importance of it is the expedience of it. When you look at juvenile brain development and how juvenile court works and why it works when adult court doesn't work for juveniles, one of the big factors is the speed with which it works. From the moment that a child commits an offense, the effectiveness of any treatment to address that offense just starts to drop off as time passes. And so it's always been part of the juvenile code to try to speed the process along. So for example, while we have Sixth Amendment speedy trial rights, and apply to juveniles, we have a special speedy trial statute for juveniles that goes way beyond what the Sixth Amendment provides and says you actually have to have these hearings very quickly because they're juveniles and because that's the way juvenile court works and that's because that's the way juvenile brains work. And so while we don't have a problem with the youthful offender extension, we do think that this is a real shift in policy when it comes to delinquencies, has the potential to turn delinquencies much more litigious and stretch out the length that these cases can take, because frankly, going through an appeal, at a minimum is going to take 5 or 6 months, and that's even an expedited juvenile appeal because you have to order transcripts of the proceeding. Like every single word that has been spoken in court up to that point has to be transcribed, has to be turned over to the appellate division, that has to read the entire transcript and record and write an appellate brief, and then the other side gets a chance to write a brief, and then the other side gets a chance to write a response brief, and then it goes up to the Vermont Supreme Court, and then it can take months or even, I've waited for over a year for decisions for the Vermont Supreme Court. So it's simply inconsistent with the pace of juvenile law. And so that's our argument for limiting the expansion of the state's right to appeal to Chapter 52A, which is the youthful offender chapter, but not to Chapter 52, which is the juvenile delinquency chapter.
So I have a question, Marshall. So your concern is not necessarily that juveniles are included in this. Your concern is the timing that it takes for.
It's the process of states' appeals in these cases are really just not consistent with the pace of the juvenile court, and that's why they've been excluded. And also because the juvenile court is a less formal, more informal process, and just generally doesn't get all of the same rights that attach to an adult process don't all attach to the juvenile process. Juveniles don't have the right to a jury trial, they don't have the right to a public proceeding, and so just like their rights are limited in juvenile court, the state's rights are somewhat limited in juvenile court as well. And that's different from youthful offender. Youthful offender, nobody can be forced into youthful offender. It's an adult status. And so in order to go in as a youthful offender, the defendant has to waive their right to a jury trial, waive their right to a public proceeding. Those are rights they have. In a juvenile court, they have a lot less rights, and also the state has more limited rights. And we think that that balance is appropriate and should remain. But we are absolutely willing that the adult rules should apply when it comes to youthful offenders, because that's really consistent with youthful offender status.
Makes me think, Marshall, I actually marked that section as a section that I was planning to ask you about, so I'm glad that you preempted my question and just answered it, because I had a little bit of concern with that as well.
But could I just add one piece? In the event that the juvenile delinquency cases took on this new ability for appeal, it definitely would have a resource issue. I don't know how many of those cases would be appealed to the Supreme Court, but when you create a new right, people tend to exercise it. And I don't think right now is a good time to be doing that from a manpower standpoint.
So maybe, can I ask Eric a quick question? So I thought that this section was about the state's right to appeal.
It is.
Not the defendant's right to appeal.
Correct.
Okay, thank you.
Eric, could you say this came from the, which group did this come?
Department of State's Attorneys.
Okay, thank you. Well, just so happens, are there any other questions for Marshall or Matt? Not, our next witness is from the Department of State's Attorneys, Tim.
Hello, Mr. Chair, how are you?
Good. Well, I'm not, I'm better.
Good. So Tim Leaderstein, one of the Department of State's Attorneys, and with me on the line is Deputy William Gardella. He's from the Chittenden County State's Attorney's Office, and I often rely on Will in other situations, given the amount of practice he does in this area. And he's from Addison County, which means he's just de facto more trustworthy, I think. So from Addison County. So he will speak to a couple specific sections. I'll just briefly lay out that I'm on the Juvenile Justice Working Group with Marshall, and on section 18, I think that's where Will may have some comments. Sometimes, and Marshall's heard this spiel before, but I sit on there to sort of monitor and help engage with that group, with DCF and with some others. And occasionally an idea will come out of there, and then I don't get the engagement from the full field until it becomes drafted into law. And so Will, I think, has a couple comments there. Still really appreciate, obviously, the working group's conversations about making some of these technical fixes on sections 18 and 19. As to the appellate rights, I think we had a conversation back in the fall based on the two Supreme Court decisions that Eric had alluded to, and agree with Marshall that, given the potential for mirror adult criminal matter, the YO fix seems to be reasonable and aligned with the way that the YO statute and its policy function are put into practice. I was thinking, I was listening to what Marshall was talking about with respect to the juvenile statutes, and I can definitely appreciate that, having not been here when the changes were happening to the YO statute. I think there is, until there, and not to bring up other things, but there is the occasional juvenile case that, we've seen, and not to parade the terribles, but where there's victims involved and things like that, where we do feel sometimes very limited in our inability to appeal. And not just in part because, I know you're working on Big 12 expansion and discussion right now, but not just in part because of certain cases not being statutorily permissible for criminal court or YO status. But in general, because these are statutes that are relative to the adult criminal statutes, more fluid, more changes recently. So in speaking with Evan Meenan, who I know from prior years, he had suggested these changes to mirror the same types of cases that the state could appeal in adult court, make them also appealable for juvenile and YO statutes. But I do hear the concerns about resources and also the intentions behind YO and juvenile being slightly different, despite rehabilitation being the foundation. So I know you're the lawmakers, and you can make a policy choice. I think we would encourage passage of the law as drafted, and potentially I could have Mr. Meenan come in and talk about some of the situations that he might see in the appellate field and his inability to practice there in certain situations.
But if I might,
Yes, Mr. Chair.
It's comment but plus question, Tim. With juveniles, it's not, it is not the same. I've been with juveniles in court who, your charge is a delinquent. It is not that you're that you're pleading to stealing a candy bar or murder. You're a delinquent no matter what the crime is, and that's where it gets difficult to for me to figure out how you include them in that appeal process, because they're really, it's a much different thing. And I've seen cases where, it's fairly minor stuff, but the kid does realize they need help. DCF knows they need help. The state and the defense all determine they need help, and they get it through this agreement. And I think to then appeal it, if part of it falls apart, I have a problem with that. And then the part about the not being able to use the risk assessment against the kid in a future case. Too many promises are made to kids about what's confidential and what's not. And I just want to know, that's, I think, section 12. And I just want to know, is that use of that risk assessment allow you to, if a subsequent offense happens, allow you to use that risk assessment against the kid?
I'm seeing the two defense bar members here shaking their heads, and I'll also have Will Gardella from Chittenden speak to some of his practice as well. But I'll just say that, you know, I've been involved in some juvenile matters that are they're not victimless, as I was stating, and despite the fact that I think you're saying the whole goal is, you know, at the end of those, there's a plan to try to assist this person, right? And even though the charge is not criminal, nor could it be, because it's the delinquency in question. One of the first cases I dealt with, that I had to have basically a 13-year-old be the state's witness, you know, in the closed courtroom, and it ended up turning out, I think, for the better for everybody. But it definitely struck me that if something didn't go well during that, you know, the timeliness of these, as Marshall was talking about, is just so important. So I hear the balance that you're saying as well, Mr. Chair. So I appreciate that. And I think I might defer now to Deputy Gardella on a couple sections I think he wanted to touch on. So if that's okay with you.
Okay. Yep, absolutely.
Thank you. Good morning. My name's William Gardella. I'm a Deputy State's Attorney with the Chittenden County State's Attorney's Office. And as Tim was saying, he just, I think, wanted me to speak to a couple of the juvenile proceeding sections. I think especially, sections 17 through 19. I think I would agree with, I'm not sure if it was Marshall or Matt who said this, or maybe Eric said it, regarding section 18 and the use of the risk and need screening. I think we would agree that's that the purpose of that screening is to determine the level of treatment need of the youth and whether that need could be met through diversion, through something other than bringing the delinquency case. And so I think if the goal there is to have honest participation in figuring out what the youth needs to be successful in that, I think it makes sense that it can't be used for impeachment even for impeachment purposes. And I can't really think of a situation where our office would have wanted to do that. But with regard to section 19, allowing the court to directly refer at the disposition hearing a youthful offender to a community justice center or balanced and restorative justice program, paralleling what the court is currently allowed to do in a delinquency proceeding. Again, I think that makes a lot of sense, but I think that provision raises an ongoing concern that our office has seen with regard to the juvenile records statute, which we are taking up in section 17 of the bill. And that concern is this, that whether it's a disposition case plan or a diversion offer, many of the services that we want the youth to engage in a juvenile case are being offered by third parties that are either referred by the court or retained by one of the parties. And the record statute really doesn't clearly deal with that disclosure of court records to that third party service provider being authorized. And sometimes judges will deal with this in their adoption of a disposition order, and sometimes they won't. And I think that's starting to make both the state and the defense in some cases uncomfortable about whether we're doing something that isn't permitted under the statute. And so that was something I discussed with Tim the other day, is whether there's a need for an additional section of an additional class of person that would be authorized to have access to juvenile case records, and that being a service provider that's retained by a party or referred by the court or the state in a diversion offer. That's disclosure issues under the juvenile record statute continue to be confusing issue.
Respond to that, because I've got an agreement that I'd like to share a little bit.
Senator
Marshall, what did you just, I didn't hear what you just said.
I just asked if I could tag on to what Attorney Gardella just said.
Yeah.
And I agree completely. I think one of the biggest problems that we have right now in juvenile law is the confidentiality provisions. There was a recent decision by the Professional Responsibility Board that was adopted by the Vermont Supreme Court called In Re Cobb that kind of threw into question a lot of the practices that we have traditionally used around sharing information. And so I completely agree with Attorney Gardella that this is getting to be a problem. I don't necessarily believe that we need to make changes to allow for those documents to be shared, but I certainly understand the concern of getting more and more consults and dealing with more and more litigation about the confidentiality of juvenile records than I ever have before because of these recent decisions. And I think that there's been a lot of discussion and pretty much universal agreement that we need to take a whole look at Section 5117, which is the juvenile confidentiality section entirely, and really take a new crack at it, because frankly, the advice that I have to give to our attorneys is rough advice. When our attorneys call, I have to say to them, you're going, like, your ethical obligations conflict with the law. And in your case, I'm going to tell you that you have to follow your ethical obligations. And if we have to defend you in violation of the law, we'll do that. But there's some 5117's a mess. So I would agree. And if there's any, I'd be happy to support if Attorney Gardella has some quick language that we could add to this section that he was talking about to alleviate that concern. But I would also suggest that a rewrite of 5117 to address not just this problem, but a lot of very similar problems is definitely.
I think Senator Bahalski has a question.
Yeah, and this is sort of a process question, so maybe a question for you, Senator Sears. I certainly hear that whole statute needs to be updated, but that seems like a bigger thing than what we would do in a miscellaneous bill, correct?
Usually.
Okay.
What we might do in a miscellaneous bill is ask the juvenile defender to work with the Office of State's Attorneys and sheriffs and the court and others and DCF and developing proposals to clarify confidentiality of records. As a provider, I'm sure if you don't get all the records, it's difficult to treat the youth. And if certain records are being withheld and the youth never tells you about it, you wouldn't know certain things, and you might discover them too late. At least that's my impression, because we always got all the information back. But I'm talking 15 years ago.
Yeah, and I'm certainly not denying that there might be a need to update the statute. It just seems like a bigger undertaking than a miscellaneous bill undertaking.
And just to be clear, I was definitely not suggesting that I could rewrite 5117 now. That's been something we've been talking about for years.
Okay.
I haven't done it because it's such a big project. We always look for something easier.
And I think that speaks to when I sent out this bill to some of our practitioners, this came up from a few folks, and that's why I brought on Attorney Gardella to flag it. I think it turned up the rock, and now we can hopefully address it with Marshall and others.
If Attorney Gardella and Marshall can get together and there's some simple fixes that could be done to help the situation, I'm happy to consider them next week when we take up the bill again. But if you get those fixes to Eric early next week, it would be helpful. think we're taking up the bill next Thursday, Peggy.
Yeah.
Yes, Thursday at 10:45.
Well, if you can get them to Eric earlier than like by Tuesday or Wednesday, it'd be helpful.
Okay, I'll make sure folks are connected. Thank you, Mr. Chair. And I didn't have any other comments. Thank you for the time, and we appreciate, a lot of these technical changes would be helpful.
Thank you. In committee, if there's other things you think of that we should be adding here, now is the time. But I would like, Eric, for you to check on with DMV on this interlock issue and the other issues raised by Mr. Silva.
Yes, sounds good. We'll do, Secretary.
It seems like for some reason, careless and negligent driving is the default reduction in sentence for a DUI frequently. And yet some of the consequences of the careless and negligent are more severe than the DUI.
Mr. Chair, could I actually speak to that for one moment? I think it'll be helpful.
Yeah.
Hopefully. Yeah, as the former DWI guy in Washington County for the state, you're correct. 98% of the DUIs will resolve as a neg op when they are going to resolve down, as you've suggested. And sometimes what we would get from the defense bar was the request to keep the DUI for the reason that you're talking about. So they would say, we're not going to resolve with the negligent operation. We would like to resolve with the DUI, and the person has the ability to do the interlock so that they actually will be able to drive sooner. And it took me some getting used to as well, because I had always assumed the DUI was the harsher conviction. But in terms of people's ability to get back on the road, the neg op as an automatic function is there. So I would want to confer with our traffic resource prosecutors a little bit. Happy to have them take a look at the language too, but you are correct that in practice, that's definitely very, very true.
Okay, thank you. Well, why don't we take a break until 10:30, and we'll hear from BSEA and others, and then have a discussion of the new